I'm not saying. I was looking at the
Yeah, Brian was next. He had my jacket. The lights up is not real good. It seemed like it was a matter of
You know what, I walked by 2 days ago.
Hi, everyone. We're going to start. So this is our second town hall regarding becoming home rule. I know some of you were at the first Colorado Municipal League was here and gave a lot of information. Tonight we have Corey Hoffmann, our town attorney, and he is here to give a little bit more information and answer any questions.
I think I'm supposed to go to the podium, so I'm gonna.
Okay.
Well, good evening. My name is Corey Hoffman. I'm with the law firm of Hoffmann, Parker, Wilson, Carberry. We have been the town attorney in Foxfield since shortly after incorporation. And I'm going to start out with my bias. My bias is I am absolutely a home rule advocate. I believe that each community has a set of its own community values, community norms, and that frankly, what the folks in Denver that make the laws, they don't differentiate between Foxfield and Durango, Foxfield and Thornton. They make laws that are based on what the legislature compromises on and agrees on. And what the folks in Denver think might be good in a given place, in my view, aren't necessarily good for the town of Foxfield. So I want to start out with that bias because I have it. You know, I was looking through my the materials in my office as I was preparing, and I found something that was put together for the July, I believe it was for Foxfield's 20th anniversary by a former trustee. And so I was looking at the history of the town. And from what I understand and from what I've read, you know, one of the kind of the tenets of when Foxfield was incorporated was it didn't want to be part of Aurora. This was pre-Centennial. Centennial had not yet been incorporated. And so a lot of the original reasons that Foxfield incorporated was to keep its large lot residential lifestyle, to avoid being included within Aurora, and kind of I would say an independent vision, and a vision that included probably a lot less government than would be common in most municipal governments. And from where I sit, that sort of culture has continued. And so when this question came up, and it's not the first time it's come up, but when this question came up more recently about rule, you know, I certainly think from where I sit that it is very consistent with kind of the original ideals that incorporated the town of Foxfield. And so I wanted to talk briefly about what I see home rule as it could relate to the town of Foxfield. But at the same time, I really think the purpose tonight is more than anything to the extent I can answer questions. So I'm not going to spend a lot of time because I know that Kevin Balmer already made a presentation and I don't want to repeat what he stated, but he and I have done these together. We've done them separately. But recently, I think home rule has had a lot of takers in Colorado, and I think that's frankly because communities are realizing that they do want to the extent they can, pave their own way. So you've seen the towns of Erie, the town of Superior, Monument, a little longer, a while ago, the town of Hudson out in Weld County, the town of Kiowa out in Elbert County. So those are two smaller communities. They've all gone home rule, and each community, frankly, goes home rule for different reasons. But I want to talk about what a charter is for a minute, and then talk about some of the things that home rule could impact. So a home rule charter is effectively a municipal constitution as it relates to matters of local concern. And so when you think about the United States Constitution or the Colorado Constitution, and frankly, the United States Constitution is probably a better example because for a while in Colorado, we amended everything by amending the Constitution. And really, a charter is intended in many respects to be a framework. It's not supposed to necessarily have all the rules in it. It is instead a document that authorizes a community to make rules if they determine it appropriate. So, in my view, if done correctly, having a charter commission and drafting a charter is not a heavy lift. It's not a heavy lift because if you're simply creating the framework, it is just authorizing Foxfield to legislate on matters of local concern. If it determines it appropriate, it can determine it not appropriate as well. And so home rule doesn't obligate you to pass laws. It authorizes you to pass laws on matters of local concern. And I really think that distinction is important in a place like Foxfield where, frankly, the culture is not to have as much governance, as much oversight. That can be part of what home rule is. It doesn't have to be a new set of rules. So assuming, for the sake of argument, that Foxfield wanted to consider home rule and voted to elect a charter commission, I want to talk about the areas that could impact Foxfield if A, it elected to go home rule, and B, what are the types of matters of local concern that the town could legislate on, could deviate from state law. So something as easy as elections, when that election occurred, what the procedures might be for election, things like specifying the minimum age for elected officials. If the town wanted to have the age be 16, it probably could. I'm not suggesting that's a good idea, but it is the type of, just as a sort of glaring example, wanted more young influence, change the age for elected officials to 16. Governance. Right now, the town is subject to a statutory framework in Title 31 and has a town administrator. Whatever form of government the town wants, it could put into its charter. It doesn't have to be, for example, 7 members of the board. It could have a 5-member board. There is one of the cities I represent. I'm the city attorney up in Blackhawk. They have a 7-person council, and they refer to themselves as the mayor and board of aldermen. Different communities even call their elected officials different things. Both Castle Rock and Parker in their charters still refer to themselves as the town and the town councils. That was, at the time of their charters, a desire to, I think, at least in Parker, keep that small town feel. We may disagree that a town of 60,000 people can keep a small town feel, but that's why they still refer to themselves as a town council. Council, trustee, alderman, selectmen. There's any number of nomenclature that the board could call itself, numbers, which types of elected officials are elected. We would frankly recommend it only be the board, but I got to tell you, in the city of Wheat Ridge, their charter says they have an elected city clerk. Do I think that's a good idea? I don't, but the voters in Wheat Ridge thought it was. The city of Inglewood has an elected municipal judge. I believe it's the only one in the state that has that. Again, do I think that's a good idea? No, but the folks in Inglewood do, and that's, again, their prerogative as it relates to having a home rule charter. Procedures related to the adoption of ordinances. So right now in Foxfield, when you adopt an ordinance, you need to have one reading under state law, and then it's effective 30 days after it's published in the newspaper in full. Parker, for example, requires 2 readings, 2 meetings. The second meeting is a public hearing, and then it's effective 10 days after publication by title only. What does that mean? It means that their council considers every ordinance twice. The second time takes public comment, and then it's adopted 10 days after publication by title only. Publication by title only makes it a lot cheaper. You could have it published on the website, because if you don't want to spend the money putting it in the newspaper, one of the little things from dealing with matters of local concern is figuring out what your constituents want, the best way to reach them. And so something like how you adopt an ordinance is frankly one of the types of things that in a charter I think is most important. And the Charter Commission are looking at what's that balance between being responsive to the needs of the community, getting community input, and still being efficient. So how you adopt ordinances, determining, what type of notice, if you wanted to deviate from state law. Again, you can't go more restrictive than state law. So 24 hours is the minimum. Some communities want 72 hours of notice. Again, do I think that's a good idea? Probably not, because if you have a true emergency, you want to be able to have 24 hours notice for a special meeting. But it's the types of things that you have authority for. Jurisdiction of municipal courts. This is an area, frankly, the Colorado Supreme Court, we're waiting on a decision from the Colorado Supreme Court arising out of cases in Aurora and Westminster on how much a local municipal court can deviate from state law. But there is some room for deviation, and we'll find out soon how much room that is. And the last one that I think is most probably applicable to Foxfield, and I suspect is in many respects the origin of this discussion, relates to land use. So I'm going to try not to get in the weeds on home rule legal issues, but I am going to get a little bit into the weeds on this one. When you look at home rule authority, there are 2 areas that you look at. One is it in the Constitution itself? And so there are certain types of things that are in the Constitution itself. And if it's in the Constitution, you know that it is a matter of local concern. And I'm going to give an example. It's a bad example, but it is an example that is in more recent case law. The town of Telluride wanted to condemn property extraterritorially outside of its town limits to keep the valley floor pristine as you're entering into the town. Because condemnation authority for home rule municipalities is in the Constitution, Telluride didn't have to follow state law, which said you could not condemn extraterritorially for open space. And it said, we're home rule. The Constitution says we can condemn within or outside of our limits for municipal purposes. The court said, yep, a state statute that attempts to restrict that authority is invalid because the language is in the Constitution. But there are other areas of the law that are not explicitly in the Constitution, but that the Colorado courts historically have said are matters of local concern. The number one issue, in my opinion, not in the Constitution explicitly, but that courts for decades have said is a matter of local concern, is land use. And so in the last several years in the legislative sessions, the state is attempting to erode home rule authority related to land use on things like density, things like transit-oriented development, things like parking standards, things like accessory dwelling units. And these are the types of issues that if I am a place like the town of Foxfield, I say, I really think we know best how to legislate on land use related to the town of Foxfield. The position of the state government at this, as of today, is that they believe matters of land use are matters of statewide concern because, and you're getting my bias here, they are outcome-based. The state wants more density. And so the state's position is, because we want this outcome, i.e. density, i.e. maybe affordable housing, although that's not in any of the legislation, therefore it's a matter of statewide concern. My opinion is that whether or not something is a matter of local concern or a matter of statewide concern isn't outcome-based. It's based on what the legislation is. And so when the state says we want more density, that's not a matter of statewide or local concern. The matter of statewide or local concern, in my opinion, is what are the regulations? What is the land use values in this community? And how best do we fit those values? Now, what I'm talking about is currently being litigated. It is currently being litigated by Greenwood Village, Arvada, Lafayette, and a total of 6 or 7 communities against the state. Ultimately, I think some manner of home rule authority related to land use will survive because we have decades of law that says this is a matter of local concern. And I have to be able to hang my hat on the fact that people in Foxfield know best how to legislate on matters related to land use. And Foxfield's values are obviously going to be much different than Denver's. They're going to be different than Parker's. And that's what home rule is all about. If it is truly a matter of local concern, the folks closest to the people, the elected officials in the town, know best. Disadvantages of home rule. I have certainly seen what I would call a rogue charter commission. There have been charter commissions, for example, in the northern tier of Colorado that wanted to address guns and wanted to address it by saying you had to have a gun to live in that community. Do I think that sort of turns the Second Amendment on its head, but it's an example of sort of what I've seen as rogue charter commissions. If the town were to consider going home rule, you would hear me advocating for a framework charter, because the charter is not the place to legislate. It's the place to authorize legislation so that the elected officials can be nimble when there are issues that come up and legislate in a way that is best for their community. The last thing I want to talk about before I open it up to questions is what I think has been the most recent home rule issues in Colorado that really shouldn't apply to the town of Foxfield at all. And that is what happened in Douglas County. I can't emphasize enough that county home rule and municipal home rule are not the same. This meeting tonight, where the folks in Foxfield are learning about home rule and transparently having these discussions, from what I've read, is fundamentally different about what happened in Douglas County. What I read in the papers is that the perception in Douglas County was this was an attempt to consolidate power in Douglas County. Whether that's true or not, municipal home rule has a historical, starting with the city and county of Denver, tradition that is really about matters of local concern on the global sense in terms of evaluating what is home rule and what is not. In counties, they are a creature of state statute, and home rule for counties, they still have to maintain all of the functions that counties provide, sheriff, jails. And so it's a much more constrained version of home rule, whereas municipal home rule, again, is about authorizing legislation on matters that are local in nature and that matter to the particular community. We talk about land use, we talk about governance, we talk about administration, but part of the magic of home rule is you don't really know what the next issue is going to be that may or may not be a matter of local concern, because things change and we evolve. And so the reason more than anything that I'm an advocate for home rule is because we don't know what's going to happen in the next 5, 10, 100 years. But I'm always going to trust, and maybe it's a reflection of who I represent. I represent local governments. I'm always going to respect the opinions of the local governing body to do what's best for its community over those that work in the legislature. So I'm going to stop there. Happy to answer any questions.
Right now we have a municipal code that's like 398 pages. What happens to that? Does that go out the window or?
Nope, it stays in effect. That municipal code, and relatively speaking, I would tell you that Foxfield's municipal code is probably smaller than any other community I know of. It's still a robust code, but no, it stays in effect.
It does stay in
It
effect.
does stay in effect. Yes, sir.
Corey, could you talk to us about the cost to get there, and then once we're there, costs to maintain, tax changes, anything like that?
I'll start at the end. There is no cost differential between being a home rule municipality and being a statutory municipality.
Good answer.
So in the after condition, you would not see any difference. In terms of the cost to get there, the cost to get there is the cost of staffing and being the charter commission. So one of the ways that that communities looking to go home rule try to mitigate costs, there's a couple of ways. First is timing. If Foxfield were to consider doing this, I would advise having the initial question about whether to go home rule and to seat a charter commission at an April election. That gives you a very efficient time frame to get a charter done for the November election. Those are two elections that are already occurring. One would be the town's municipal election. The other would be doing a coordinated election with Arapahoe County. But from a cost perspective, having those two elections as the bookmarks is a good way to address costs related to the election. As to the charter commission, the costs are going to be dependent on how creative the charter commission wants to be. And in my view, this is a time you don't want to be creative. You want to provide templates of similarly situated communities that do not, that really is just that authorization document. This last November election, Cripple Creek has decided it wants to go home rule, or at least seat a charter commission. And so they are looking at this. Superior, Erie, Monument in the last several years have done it. And it's really going to depend on who is seated on your charter commission. Because if that charter commission gets a couple of framework charters and says, yep, this looks good, then it is an incredibly efficient and cost-effective way to get there. If you have a rogue charter commission, it could be different. And that's where the cost is going to be a question. But if it's a straightforward, it could be is what I have seen in terms of structure that is efficient is a charter typically has, between 6 and 12 chapters. You've got a governance chapter, you've got an administration chapter, you've got a budget chapter, and a couple others. And if you do a couple of chapters at each home rule charter commission meeting, I think you can get a charter done in a matter of like 3 or 4 months. So if you are that efficient, and it really is about a framework as opposed to trying to legislate through your charter, then it is not an expensive proposition. And that's why I think places like Hudson, places like Kiowa have gone through the process successfully, and it hasn't been expensive because they did a framework charter.
You have the templates for.
We do. And in fact, when we went into, and my firm represents both Superior and Erie, and that's exactly what happened. Is we walked into those communities and had some templates and said, this is why we think this would work. This is why we would think this would work. Do they deviate? Absolutely. But it should be deviations that are community specific and hopefully fairly minor.
Thank you.
Corey, can a charter be amended once it's adopted?
It can, but only by vote of the entire community. So the charter is approved by a vote of the community, and then if it's an amendment, it can be done by an initiative. So the community can initiate to change the charter. The town can set charter amendments for an election, and it can be at a regular or a special election.
That's another question. If determined, however that lawsuit ends up with the home rule, let's say the legislature comes in with some other things that really impact us regardless of our population. Can you retroactively, if you become home rule after the fact, go back and not abide by those rules?
Yes.
Okay.
So once you are home rule, you have the authority to legislate on matters of local concern, and you are not restricted as to time.
You mentioned seating the charter council, charter group. What are the different ways that you get people on that committee?
Run for office. So in April, if the town were to do this, there's 2 questions. Shall the town seat a charter commission? And if so, here are the people that want to be on it. So you actually run for this very short-term office of being on the charter commission. And it may or may not be members of the board of trustees. I think it would be ideal to have folks that are not members of the board of trustees. Some communities have had to fill the gaps with members. I see, a former mayor in here that I think would be a great member of a charter commission. But no pressure.
I knew I should become.
But no, I mean, it's intended to be very, very grassroots, and it is a short-term obligation. But when Kiowa did it, they have a very, very, at the time, and this was probably 10, 15 years ago, there was no interest in the community. It was apathy. And so they had to seat. It was mostly the board of trustees at the time that sat on the charter commission out of necessity. The community wanted the charter. They didn't want to put in the work. So it got there. In Hudson, the chair of the charter commission was the husband of the then mayor. So, there's different ways to do it in different communities, but if there is a way to get the community involved that's not the board, I certainly think that's ideal. And again, if you were to follow the April to November, you're talking about a 4-month commitment. Once a week, maybe once every 2 weeks. to get it done. Yes, sir.
Corey, would there be a representative from your firm at all of these meetings typically?
That is up to the charter commission. It can be my firm, it can be another law firm. But yes, the answer is yes.
And so Tim asked the question, I guess I would be more pointed. In your experience through these communities, and what's the rate, how much money do we need to put in the budget to make this happen?
Yeah, the difficulty is going to be if things go off the rails, but for what I would call the standard, you're talking about, I'm going to say roughly for that period of time, $1,000 to $2,000 a month. So that's, 5 hours, between 5 and 10 hours, depending on how quickly the commission moves for those 4 months. So do I think it should be done from a legal fees perspective for under $10,000? Absolutely. Absolutely. Because you're looking at a short time frame of writing the charter, working with, the charter commission would be staffed presumably by, I'm guessing, the clerk and the manager to assist, and then our office to assist in drafting the documents, but we're not drafting from scratch. And that's, again, if it is that framework, there's a lot of changing the name to protect the innocent from to Foxfield from some other community. But there's very few issues, I think, that you really get in the weeds on. Things like composition of the board, things like how you adopt an ordinance, those are the kind of things you spend a lot of time on. But that's the charter commission having a discussion about what's best for the community. From a drafting perspective, it's pretty easy.
Is there a required amount of participants in the vote required to make this change?
You need a majority, but you need 9 members on the charter commission.
Majority of what?
A majority of the voters of the town to approve the charter.
Of the votes received.
Yes.
Okay.
Yeah.
Thank
Oh,
you.
yeah. So there's no minimum number. If 50 people show up, you need 26 votes.
Sorry, that was my question as far as, so a vote is required to, approve the charter, amend a charter. However, no votes are required. It's strictly a vote of the elected officials to do any legislation or adoption of ordinances.
Correct. So part of what will be in the charter is exactly that process. How do you adopt an ordinance? So again, I don't think this is a good idea, but hypothetically, the charter could say you could only adopt an ordinance with a unanimous vote of the board of trustees. Do I think that's a good idea? No, I still think it should be a majority. But you can even look at what a quorum is. So all of those things, the charter will dictate how the board moving forward were to act. That's one of the chapters.
Well, Corey, a lot of what we're doing right now is the statutory town works. So it's not like you have to change everything.
Yeah,
So,
exactly.
yeah.
So, and again, from my perspective, I agree 100%. Where I would probably think there could be a way to make things more efficient would be, do you want to publish an ordinance in full every time and wait 30 days after final publication for it to be effective? If you have the process at the front end, might it be better to have it go into effect more quickly? I think most communities that have a charter think that's better because then it allows their board to be nimble. But I agree, a lot of the things that are in state law can essentially be continued. And one of the provisions that is in any charter, so under Colorado law, there is a portion of the Colorado Revised Statutes, Title 31, that is called municipal corporations. And all of the stuff related to municipal corporations is incorporated by reference into a charter unless it's specifically deviated from. So you include all the stuff we've been operating under anyway, and then have the ability to legislate differently on matters of local concern, if the town chooses to.
So for the charter of 9 people, the level of knowledge or expertise required so they can make proper decision making. Obviously, the firm would be the advisors. They may give 4 templates and say template 1 to 4, and each one has these differences. So would that be coached, or because assume all 9 members are very novice, they have no idea or how to do what to do. I mean, what level of hand-holding is involved so that the charter team or what we are putting out is the ideal one, right?
So the expertise required to be on the charter commission is to be a resident of the town. And I think that's an important expertise because you're looking at what makes Foxfield different. But as it relates to actually translating that into a charter provision, you know, it's really about what do we want? What is the bare minimum for governance that the town needs in the charter? And yes, we would absolutely say this has worked in other similar communities. But you know, my takeaway from working with the town of Hudson was they spent a lot of time on how do we want to be different. And my suggestion is you don't need to do that in the charter. You really do just need to have the template that allows you to legislate later. So to the mayor's point, what works doesn't need to be fixed. It ain't broken. So it really is a policy driven, here's what works for the town.
Do you know why, when Foxfield was developed, it wasn't considered home rule?
You know, it was, I know that the incorporators talked about it.
Okay.
I don't know why they did not do it, because many communities now, when they incorporate, they also do their home rule election concurrently. Foxfield didn't. I would speculate that this, from reading my historic materials, this was a heavy lift by volunteers. And I think that might have been the extent of the heavy lift at the time.
Lori, I have a question online. It says, how do we get 9 people to participate? We have had a hard time getting people to be trustees.
I don't know how to answer that question. You know, other than, you know, it is the equivalent of a constitutional convention. And it is a 4-month obligation as opposed to a 4-year obligation. And so, you know, I would like to think that there are folks in the community that think it's important enough that the short-term obligation, you got a long-term benefit. And, you know, for what it's worth, when you look at a code set, a municipal code of a home rule municipality, the first part is the charter, and you have all the members of the charter commission. So they're sort of, they're there forever as the people that worked on the charter and created the charter.
So is this I guess I'm trying to wrap my head around how the charter commission operates. You gave so many examples of, can you do it? I wouldn't recommend it. You really made me nervous here, Corey. Are these open to the public? What kind of public feedback goes into this process so we aren't stuck with a terrible charter when it goes up in November?
Yeah, public, these are all public meetings. The Charter Commission is a local public body, so it is subject to the open meetings law. You know, I would hope that Foxfield gets a lot of involvement, but I would also hope we're able to talk about when you have, again, what I would call the vanilla framework charter, here's why it works. And if it goes off the rails, the remedy is to vote it down. It happens occasionally, in my experience, very infrequently. If the community has a vision to just be home rule, then the charter's simple. If there are motives on the Charter Commission that are not consistent with that policy direction, then yeah, things can go off the rails. But it has been, the example I gave about the guns was probably 20 years ago. More recently, there's a community sentiment that is based on, good motives. It's been a pretty simple process. But that's a matter of knowing what the community is and knowing what the community wants. As I've advised Foxfield over the years, that the values related to the large lot residential have been so important. And the idea of less government is more has been so important. And trying to translate that into a charter provision that gives you the ability to do things when you need to. But I can't emphasize enough, authority doesn't mean obligation. It is just authority to legislate if you need to, but not an obligation to legislate.
Does the committee work? If you have 9 members, do all 9 have to agree on every provision? So who?
So it's a majority vote, just like any other local government. But again, my experience has not been that you have 5-4 votes. My experience has been you have a lot of discussion about why is it important to have this particular process for adopting an ordinance. Hudson believed it important to have their own language regarding what is authorized for executive sessions. That was important to them. North Glen has language in its charter from the mid-70s on executive sessions. It really depends on what is important to the community. And those few issues that matter are typically the matters you spend a whole night on in terms of getting to yes. But in my experience, it has been a collaborative getting to yes experience.
I have more questions online. Someone said, I moved to Foxfield 20 years ago because I like the culture and environment that we have experienced here. Am I correct in assuming that this change will help us keep things the way they have been, or is this motivated to make changes? If change is desired, what are those changes?
I can't speak to the motivations. I can only tell you that my understanding of why this has come up again relates to a lot of the land use stuff at the state level that Foxfield would like to resist. And so I think from what I have understood, it is a matter of keeping the status quo and trying to have the tools to keep what makes Foxfield Foxfield. But that's my understanding. I think it's probably a better question for the board.
That's a good answer.
She said.
Yeah.
So basically, as a statutory town, we're remaining, let's just pretend we're remaining what we are right now. Given the land use that's out there, what are our protections right now against some of those codes that we might not particularly agree with?
Well, right now, a lot of the codes haven't applied to the town because of its size.
Yes, but that could change.
If that changes, the town is a creature of statute.
Can you elaborate on that, please, just so we all
Yeah,
understand?
yeah.
Thank you.
The Title 31 that I was talking about that applies to municipal corporations, the town has to follow those laws, and its authority is framed by those laws and anything that is necessary and incidental to implement those laws. But it can't deviate from them. And so I'll give a really wonky example.
Oh, I meant on the size clarification as far as the
Oh, there's state law that only applies to communities over 2,000 right now,
2001.
residents,
Okay,
people.
Okay.
But that was a random decision by the legislature to say this only applies to communities over 2,000 people. There's also other legislation that only applies to communities over 10,000 people. But if I were a resident of Foxfield with my large lot residential, I might fear that if those density requirements were changed and it said it applied to communities statewide, someone could come into Foxfield and start taking the large lot residential and say, we're going to subdivide them into 6, 8, however many lots. And if that's in state law, as a statutory town, the town would not be able to deviate from that if those rules were imposed upon it. That's not where we are today. But it, in my view, it could happen. And so I'm going to give a really kind of arcane example of what, when I talk about if it's in state law and you can't deviate from it. In Estes Park a number of years ago, they did something that was, and I don't remember if the term was for advertising or marketing. And the state law said you could do advertising but not marketing, or maybe vice versa. And they did it. And the court said no. Because it said marketing and not advertising, you can't do advertising. Now, after that happened, the Estes Park went to the legislature and said, this is silly, change it. But it took the legislature at the state level to change it, because otherwise they wouldn't have been authorized to do it. As a home rule municipality, you don't have to have that discussion. If you were having something that was a matter of local concern, you could deviate from state law without going back to the legislature and saying, this is important to us.
Sorry, I didn't mean to hijack your question.
No,
Corey, wasn't there some of the new legislation that applied to populations of 1,000 and less?
You said
So we're,
2,000, so we're
some were 2,000, but.
yeah, it's all over. I mean, they have,
Yeah.
every piece of legislation has an applicability provision. And, Foxfield is unique in that it's in the metro area. And so it is seen as being a part of the metro area, even though when I come to Foxfield, I think it's kind of a little haven that's not. But nonetheless, as questions about density continue, and I do not want to suggest I'm saying the sky is falling, because I don't know what's going to happen in the future. But I still think that Foxfield controlling its own destiny on matters of local concern is better than the alternative. Even if this issue about density at the state level doesn't play out the way some of us fear, there will be other matters where local legislation matters. And again, with my bias.
And just to make sure I understand, like, I obviously have a bias as well.
Yeah.
That would allow 4 of our 7 elected officials control versus the state legislature controlling those items.
Correct.
Well,
Yes.
Ray, would you recommend that there be at least one board member, just simply because a lot of the residents, and I think J2 brought this up, don't have any experience, they don't understand any of it? I mean, is it going to be a big learning curve for them?
It may, but I think having the board involved and frankly being in the audience might be just as effective.
Okay.
Again, if there is the interest, because I think this is much more big picture. And going back to your point about the 4, it's also a lot easier to unseat those at the local level than it is at the state level.
And I understand that, and I know a lot of this is tied around elections, of which we haven't had many. There's been a significant number of appointments as opposed to elections
Yep.
as well.
Yeah, and that's a reflection on interest.
Yes.
And the city of Blackhawk has about 75 registered electors total. And so they're actually considering whether to amend their charter to go down to a board of a council of 5, because they actually have had a lot of interest. But there's 75 people in the entire city. And so, that's the type of thing that communities can look at so that they can get a better, but again, I still think the elected officials that are closest to the people are best, but that's a bias of representing local governments for 30 years, and I get it.
First, you had some online questions still?
Yeah, I do. So someone said administrative cost is high for charter compared to other. How to control the cost and how to manage risk of frequent amendments.
I can't speak to the cost. I think is based on how the Charter Commission operates. But as it relates to, and sorry, want to say that again?
This is how to manage risk of frequent amendments.
The risk of frequent amendments, you have to have an initiative of the people or the board setting a charter question for an election. So it's not easy, and it takes a majority of the entire town voting, I mean, those that vote, to change the charter. You know, if you look this past November, the town of Parker had a number of charter amendments. They were all cleanup and they all passed, but they weren't substantive. They were frankly bringing it current. North Glen had a charter amendment about 3 years ago now, and a lot of communities had, I think Aurora might have had this charter amendment this last election, to make their charter terminology gender neutral or gender silent, depending on your perspective, so that it said, you know, chairperson instead of chairman. So it can be things as innocuous as that. But it's actually a heavy lift to amend a charter. It's not just done by the elected officials, it's a vote of the people.
If it's a.
I think to follow up that question to the amendment, because it's more nimble and agile when you are coming to the amendments. So that's why I was like, it's when you are city, see, all the citizens or the people in the city need to be more engaged, and then sometimes knowledge of the laws, something paying attention is very important, right? That's where I'm like, it's very gets complicated when you are more agile and things are nimble. That's why I'm asking that question.
Yeah, and I think that when I talked about being nimble, that's really about the board's authority under a charter to act. But it is in most communities very rare to actually have charter amendments once you have your charter in place. Unless there is something, so I'll use the town of Parker again, had a limitation in their charter on how much a fine could be in the municipal court. And state law actually has a limitation on fines in municipal court. And state law raised that fine to $2,650 a number of years ago. And Parker was still at $1,000 a day under its charter. So those are the kind of things that, if Foxfield were considering a charter, I'd say for municipal court, you stick to state law on the fine amount. So that's, as state law changes, you change with it. That's the kind of thing that I don't think is necessarily what you want to put in a charter, because it's too specific and things change.
Thank you for answering that.
If it's a plain framework charter, is there an administrative or cost difference afterwards, or do we operate the way we did?
None whatsoever. No difference at all.
Following up on the question about the committee, you said that they run for election. It's not we agree to certain people can run, it's whoever wishes to run, correct?
Yeah, that is a resident. Yeah, you just have to be a resident.
It's just like running for the board. You
Exactly.
Put your name in the hat. Okay.
Exactly. And
You seat the full 9, don't you, or you vote individually?
you seat the full 9 and you hope you get 9. I mean, I hope you get 12. So you're actually having a vote. But if you get 9, you got your commission.
So if we have 9 run, they're seated, but if we have 12 run, do you vote for them individually or no?
Yes, you get
Okay,
the
then you
9, the
actually
top
get
9 votes would get it.
Okay. Because you mentioned, I think we had that online question about what was the motive? Well, this seems like a very resident-driven process. So really, I would be more concerned about what are the motives of the people who are wanting to be seated on the charter committee is more relevant than why it's before us right now. So.
Well, and I think the goal is to have folks that run for the charter that are aligned with those that are talking about why it might be important.
Yeah.
Who decides if we want to move forward with home rule? The board?
The board puts question on the ballot. And the first question on the ballot is, shall we form a charter commission? And if so, who is elected to the charter commission? So the board puts the question to the voters hypothetically in April. And if the residents vote against creating a charter commission, it's dead then.
So Corey, let's say 9 people come forward and residents are going to vote. If there's 9, do they have to seat all 9? What if there's a resident that the community knows is broke?
They still have to seat all 9.
Okay, so
If you have
it's more
10.
than 9, then you can, okay.
But no, you can't, there's no blackballing of someone that runs if you don't get the requisite number.
Who appoints any MD, because we appoint a lot, who appoints any vacant seats on the charter commission?
My recollection is the charter commission does it, but I'd have to check that.
And, you know, we have a very tight time frame. So if someone for some reason had to drop off,
You would still be able, you
you could
it's
still go- move
quorum
forward.
requirements, yes, you're still okay.
So it's similar to the town trustees appointing people for vacancies or for.
Yeah, but again, this is gonna go, again, if it's approved, if it were on the ballot in April, and if it were approved, you're talking about basically a commitment from mid-May, end of May, till July or August. And then charters out there, and then voted on in November. So it really is a short obligation.
Now, would the charter needs to be before the election itself, presented, roadshow sort of thing, details?
Yes, there's a whole process for how the charter, it goes to the board and ultimately to the voters. But yes, it is vetted.
What's the normal timing for that after the committee approves it?
It is roughly, and it's something like 60 days prior, give or take. And I'm going on memory.
So they gotta be done by mid-September.
Yeah.
Yes.
Yeah, the ballot content has to be certified in the county by roughly the second week in September for a November election. So it creates an artificial timeline of having to get it done quicker to get it to that November election, which is one of the ways you artificially make cut the costs.
So what's the steps to get it approved after the committee? Is there 30 days of publication, the board has to vote? What kind of things have to happen there?
It is presented to the board and then the board sets it for an election.
So the charter commission worked on the charter, presented to the board for XYZ reason, board says no. So end of story, or it's?
No, George still has to, ultimately it still gets put on the ballot.
Irrespective if the board doesn't approve it?
My recollection is that the charter commission, the board can send it back, but ultimately it has to be placed on the ballot. And I'm going on memory, which I should have brought my statute and I didn't.
Can you confirm that we would vote on individual members of the committee? So if 12 people run, can we vote for 11 of those 12 to be on the committee?
9. So yes, if 12 people run, 9, based on the size of the town, would get elected.
I think the question is, if 12 put in for it, when we're marking our ballot, we get to pick 9 of the 12.
Correct.
That's correct.
And if you only get 7, there is the option of board members.
Or to appoint others.
Or to appoint others,
They would be appointed by the charter commission.
That's right, yes.
So.
I need to double check if it's the charter.
Commission, would a
but
board
yes,
member be on?
they are appointees. But again, from a community credibility perspective, I can't emphasize enough how important it would be to try to get those at least 9 running.
Yeah.
It sort of reinforces the need to the community to at least consider whether this.
Well, I agree, but if there's 7, then they're appointed, and then after the fact, they have to go out and recruit 2 more. And if they're unable to do so, because we have such a short time frame.
We'll have 2 vacancies on the commission.
Okay.
Can the charter get through with vacancies?
Yes.
So you don't actually need 9.
You need a charter commission of 9, but if you create the 9 and then have 2 vacancies, you still have a charter
Oh,
commission.
So you have two people.
I mean, I can't, and so that's why I can't emphasize enough, if the town wants to do it, it should have that interest at the front end.
In the case of two absentees, would it be majority or would it be majority of the committee?
I'm going on memory, but I think it's, you need 5. I don't, so.
Can you please address risk of unclear authority if the charter is vague?
It is the same as any other statute or any other code. Yeah, you want to make it not ambiguous, not vague. And frankly, that's why these ideas of using template charters that are tried and true is so important. Because it eliminates, and most of the time, charter provisions are not challenged. Because if you're doing it right, the charter is like the Constitution, which is really just giving authority to do things, as opposed to the risk in my mind to the town is if its ordinances are vague, because those are the laws of the town, as opposed to the charter, which is the framework that authorizes the laws.
How do we volunteer for consideration?
If the town does this, I think the town's going to do a lot of outreach to say that this process is moving forward.
Arm twisting.
Arm twisting, outreach, yeah, exactly.
And the question is, what paperwork do we have to fill to have our names on the ballot?
It's very similar to running for the board. I think it's an affidavit of intent and basically get a couple people to sign a petition.
And Karen will have all that information.
Yes, Karen and Monica will have all that information.
And we can post all that on the website.
Corey, is there any urgency on this, given that at this moment in time? So my question, I suppose, is I do deeply care that we haven't had a competitive election in quite a while. 2016 would be. 2020, we did have a write-in candidate, so we did hold an election, but 2016 was our last truly competitive election, I think. I personally would like to see the board fully elected before proceeding with this, and I guess I'm concerned that if we are trying to find a charter commission at the same time that we're running an election for 4 seats on the board, that we're gonna shoot ourselves in the foot for getting any candidates elected to the board. So I guess is there urgency that we can proceed with our election and be in just as good a place, maybe a year down the line, to pursue this?
I think that's really a policy question. But I'd say 2 things. One is my aspirational hope.
I know.
Well, no, would be that this might actually help get involvement for the board as well.
Okay.
In terms of urgency, there's not urgency in terms of time and effort. With one caveat, doing it the year the town has its regular municipal election is a significant cost savings, because you already have the municipal election scheduled, and then you have the November election already going as a coordinated election. So from a timing perspective, doing it in an even numbered year
Okay.
certainly helps.
Assuming there is an election.
Right, but there is a
It's
schedule.
been 9 years since we had.
Yeah, but there is a scheduled one
Okay,
under the.
but that's the cost savings.
Yeah, as a statutory town, you have municipal elections in even numbered years.
At what point does the board have to vote and approve for it to be on the April ballot?
I think it's January, February, roughly.
Don't the candidates for our typical elections have to be in by like 3rd week of January or something?
That sounds right.
Because I know it's like mid-January or so, because if you don't have enough, then you call it and don't do the election at all.
And we can certainly, one of the things we do is provide a calendar of all of those things that can be placed on the website as well. And we, again, we have not predisposed whether this is a thing or not.
Oh,
But if the board says, go ahead and prepare this. We can prepare a lot of these materials and say, here it all is, and it's ready for the town to digest.
So the question about going back to the templates, let's say an example, 4 templates. Is iteratively those templates have been, template 2 was sort of developed off template 1, template 3, because of ABC reasons, this was modified. These are the pros and cons. I mean, when I'm looking at it, will I be getting educated on those things?
Yes, and you know, we, depending on what the commission wants, we can give plenty of examples of very detailed charters that have caused problems. You know, there's a provision in the Canyon City charter that says that any expenditure over, I think, like $7,500 has to go to the council. And for a community the size of Canyon City, that means that you're going to the council on everything. And so from a nimbleness perspective, it ain't nimble. I mean, Canyons, and we're the city attorneys for Canyon City. They have a very, very long charter. It is not a template charter. You know, I'll give an example. There's a chapter in North Glen's charter that creates a board called the Citizens Affairs Board. Now, granted, North Glen is a community of 40,000 people, but it has the Citizens Affairs Board that was created to be an extra governmental entity. In other words, you can't be a member of any other board, and it is intended to be a place where people can go to this board to complain about things in the city, and they're not supposed to be allowed, they can't have any other position. North Glen has tried to repeal, has put that question on the ballot 2 or 3 times over the years, because really it's not used very much. People want to keep it because they think the idea of having this board out there, if it's ever needed, is a good thing. But it's a chapter that I think every city council I've represented since the early 2000s there said, why do we have this? It's a waste because no one uses it. They keep it anyway. It's the community. The original incorporators and fathers of North Glen thought that was a good idea, and people don't want to change it.
Questions?
I mean, like, is there a urgency to move to charter, or is the state enforces? I think I was not there in the beginning, first meeting. There is no enforcement, right? It's up to us as a city, we can decide.
Correct. So the way the law works as it relates to home rule charter is that in the Colorado Constitution, there is an authorization to go home rule. And if you exercise your constitutional authority to go home rule, anything in a home rule charter on a matter of local concern can deviate from state law other than the Constitution. So, for example, a home rule municipality cannot deviate from Tabor because Tabor's in the Constitution. But if there is a state law that is a matter of local concern, the town would be able to deviate from that state law. But it is the town of Foxfield's home rule charter. So the state would never be enforcing a home rule charter. It is the town's obligation to enforce the provisions of its home rule charter. But as part of enforcing its provisions of the home rule charter, it has the courts that recognize, just like any other law, that home rule municipalities have certain authorities. So the town still goes to Arapahoe County District Court if it has a dispute that needs resolution. The law is just originated from the Colorado Constitution as opposed to Colorado statute.
Got it. Thank you.
Is there an expected timeline on that 6-city lawsuit resolution? Okay. I realize that's always throwing darts at dark.
I mean, my best guess. So the state has filed motions to dismiss based on a number of things. The judge will rule on that. If he grants the motion, it'll be done quick, but I don't think it will be. So I am guessing this is a year to 2 years out. And once that decision is made, whatever it is, my hunch is it'll go straight to the Supreme Court. So I think we're a ways out.
But my understanding is, and I may be wrong on this, that those lawsuits are centered around similar disputes, that the original motivation for this would also be to protect or control us against land use issues related to home rule.
It is.
Okay.
And, you know, knowing just enough to be dangerous about various communities, I know that Greenwood Village was one of the advocates for this, the lawsuit. And, you know, they obviously have transit-oriented stuff on I-25, and so they believe this was too important of a negative impact on them potentially moving forward to allow it to sit. So.
Are we at risk of transit-oriented development?
Can you define, just elaborate on what we're talking about related to that
Well,
in a practical?
yeah, transit-oriented development, kind of in a big picture, is this idea that to avoid having more cars on the road, you have density near transit centers.
Okay.
And so you look at the light rail, you look at where RTD goes. There's no plans for light rail going to Foxfield.
Sure isn't.
Um,
Oh, Boulder, kill us first.
But
There's 100% no plans.
But you know, and RTD is certainly not popular right now. But the idea of bus-oriented development and the possibility of whether it's Arapahoe and Parker Road sometimes at some point being designated as transit corridors that triggered more authorization for density, it's certainly not impossible.
Property.
And you know, that as part of the land use discussion statewide, you know, there's been references to, and never been to Houston, but Houston is an example of a place that has very little zoning regulation. And if I use the term Euclidean zoning, do people know what that means? Okay. There is a United States Supreme Court case that came out of the city of Euclid. You therefore refer to the zoning as Euclidean. And it is where you have a residential zone district and a commercial zone district. And it's sort of how communities have developed. Houston does not have that at all. It is a hodgepodge. I think there is concern in many of my home rule clients that the desire in Colorado is to sort of get rid of Euclidean zoning.
Is there any evidence of that?
The idea of putting density in the way that the state is doing it suggests it's sort of a first step. I mean, and again, I've told you all
It
along.
seems like it seems like an extremist example. As someone who has lived in Houston.
But that is the concern, is how do you meet the influx of folks? And this is a statewide issue. This isn't a Foxfield issue. It's really what the concerns are statewide about taking away the ability to regulate how land is zoned. You know, I've referenced Northglenn a couple of times. I've been their city attorney for many years. They are the first planned community in the United States. So it was a Perlmutter planned community. They're the first subdivision, if you will. And so they are probably the most traditional, in many respects, Euclidean zone community, because you have a huge residential swath, and you really only have, you don't have any, you have almost no what I would call neighborhood commercial. like you would now in Denver and, if you look at new development in Arvada out, you'll see little pods of mixed use. You don't have, traditional Euclidean zoning doesn't have that. Is there some room in between? Absolutely. Circling back to home rule, you can put whatever rules you want related to land use. You can have uses that have conditions that as a statutory town you can't do. So it's really reacting to your land use environment as a home rule municipality.
Well, and the reality is, if we were home rule, there's a prayer that we can control things. If we're statutory, out of luck.
It matters of local concern, and land use is very much a traditional matter of local concern. And so, one last example of why home rule isn't, I don't want to say it's the cure-all, because it's not. One of the first home rule cases that I tried, and I like to talk about my wins, but I'll talk about a loss. North Glen had a house that was a foster parent that housed only juvenile sex offenders. And so North Glen passed a zoning law that said you could not have more than one juvenile sex offender residing in any house. The Colorado Supreme Court overturned that and said not that it was a land use regulation, but that it was preventing the state from placing sex offenders where it deemed them appropriate. So instead of saying you did an improper land use ordinance, it changed its character and said it wasn't a land use ordinance, it was impeding on the state's ability to place sex offenders where it thought appropriate. So part of this law is how you characterize things, and you try to characterize land use laws as land use laws. In that particular case, they said it's not a land use law, it's an attempt to circumvent state law about the placement of sex offenders. So it's not the be all end all, but it gives you more authority.
Anything more? Okay.
I'm just proud of all the questions that
Oh,
are
they're
coming in
great.
here. I mean, everything you asked in there. We're interested.
Thank you, Corey.
Absolutely.
This was very well done.
Thank you, Corey.
Thank you.
Thank you.
He thinks.
At the end of the trial,
No.
Thanks so much, everybody. Really appreciate it.
That's him. That's what I'd like
You
to.
gotta go.
Yeah. This is a lot. Traffic. Yeah.
Sorry, I'm Stacy Duffy. Hi, nice to meet you. Sorry.
She nailed it.
Sorry.
You're.
If I did it right away.
When you're young, you're correct.
Yeah, short.
I have a lot of practice, so I don't need to be argumentative.
Then you're.
No.
No, I was an HOA for 6 years. I moved to a place without an HOA because I wanted to see property. and I didn't want to-
To use that.
So that's my headline. So I'm just a personal. I don't believe that consolidated.
Say hello, Monica.
Well, if you wanted-
I